Mission.
Hi, this is Joel Persinger. I'm the Gun Guy. Thank you very much for watching my channel and supporting GunGuyTV. I'm very, very grateful that you do. There's a couple of things I want to tell you before we get Sam on here to talk about the changes and victories that we've had recently with the Second Amendment. First and foremost, I want to let you know that GunGuyTV is no longer a prisoner of YouTube. We are on a whole bunch of other platforms, which you can see on your screen right now. So if YouTube goes away, or if you just don't want to watch us on YouTube anymore, you can watch us on any of those places. Be aware that we're currently finishing up the copying of the entire channel on Facebook and Vimeo. Everywhere else, it's already been completely mirrored. And then as soon as we get done with Facebook and Vimeo, rather, I'll let you know. But you can go to all these other places and check us out there. You'll also notice there's some advertising again on YouTube. I had shut it down for a long time because I was ticked at YouTube, but frankly, we need the revenue, so I turned it back on again, so you'll have to forgive us for that. If you'd like to support the channel, you can do it by supporting us on Patreon. There's a link in our description for you to do that. You can also, if you'd like, just shop our Amazon link. It's on our website at GunGuy.tv, and if you click on the little banner on the top, which you can see on your screen right now, then you can buy anything you want at Amazon. Costs you absolutely nothing, and we get a little bit of a commission, so it does help out quite a bit. All right, now, before I get Sam on, I want to let you know there's a bunch of victories that happened recently, and one of which is one of the ones we're going to talk about, is very interesting to me, and probably to you too, because it covers something that we all call open carry. And there's actually an article about it today in Town Hall that says Hawaii and California's huge Second Amendment victory. Just to give you a little bit of context here, the story says Tuesday's decision by the Ninth Circuit Court of Appeals means that people in the western U.S. will now be able to openly carry a handgun in public. The decision only applies to districts under the Ninth Circuit jurisdiction, but it will likely soon affect the rest of the country. It is a huge ruling that strikes down existing state prohibitions in Hawaii and California. The case involved George Young, who wanted to publicly carry a firearm in the state of Hawaii for personal self-defense. Young applied twice for a handgun permit to carry, either openly or concealed, but they denied his application each time. Hawaii's law requires a demonstration of, quote, reason to fear injury to the applicant's person or property, unquote. Similar rules apply to open carry, but in fact, Hawaii refuses to acknowledge that anyone has good reason to fear for their safety and is not issuing a single permit. It goes on to say, closer down at the end of the story, that gun control advocates could appeal the three-judge Ninth Circuit decision to the entire Ninth Circuit or to an en banc panel. The court as a whole is very liberal and may very well reverse Tuesday's decision, but such a ruling would definitely be appealed to the U.S. Supreme Court, which may or may not hear it, and hopefully would overturn it if they did. So with that little bit of background there, let's see what Sam can tell us. Sam, thank you very much. You are one of my favorite people, and I'm glad you're on the show again.
Joel, it's always a pleasure. I learn as much as anything when I have a chance to talk with you, and we delve into these very important issues. And this issue in particular, your listeners have to pay very close attention. That article, although it is very positive and ultimately may be borne out to be totally true, is not exactly accurate. The ruling does not allow us to magically begin to open carry in California or within the Ninth Circuit Court of Appeals yet. The ruling has not been finalized because the final disposition will happen once either there is no en banc challenge, which is a request by the state of Hawaii, or, get this, any judge that sits on the Ninth Circuit Court of Appeals can ask for a en banc hearing. That's a panel of 11 judges instead of just 3 judges. And those judges can set aside the ruling of the 3-judge panel, or they can uphold the ruling of the 3-judge panel. Once that takes place, the determination is made whether there is going to be a en banc panel or not. Then the case will be finalized. Then what this thing does is it invalidates the law in Hawaii. And it gives us opportunities to sue in California to have our open carry laws overturned. It doesn't magically, automatically negate the laws that are on the books. It sets a precedent that can be used in order to challenge the existing laws. So we're still looking into the future. It's still going to take lawsuits to have our rights restored. Please do not go out and all of a sudden open carry saying, yay, Young versus Hawaii, we can now open carry in California. Do that, and you're guaranteed to get a visit from your local law enforcement agency, and you will spend some time in jail and spend thousands of dollars protecting yourself, just to learn that, no, you don't have that, that the government doesn't recognize that right in California yet.
Yeah, and I think that's key, because I have, thank you very much for clarifying that, by the way, because I read that article and I thought, wait, whoa, hold up, because I have gotten a lot of inquiries recently about that. Can we open carry now? And the answer is no, not yet. But like you said, it's a process. It still, I think, at least from my perspective, it seems like it's a huge win, no?
Massive victory, Joel. This is huge, and this is why people need to be engaged with the organizations that are carrying this fight forward and looking down into the future and playing the long ball game here in order to get our rights restored in California and the rest of the country, and then we can just protect our restored rights. But none of this would happen if not for the efforts of certainly gun owners of California and all the amicus briefs that we've been involved in, but our cooperation with the National Rifle Association, the California Rifle and Pistol Association, you know, the Second Amendment Foundation, Firearms Policy, all of the groups that are out there filing lawsuits to restore our rights are part of the process that are bringing us to this kind of a situation. Now, this case is interesting because Young didn't have an attorney. He represented himself in Hawaii and appealed it on his own. It's a legal term called pro per, I think. And forgive me, lawyers, if I messed that up, but that means that you're representing yourself. And this was kind of a surprise case that they took it up. But Justice Diarmuid O'Scanlan, who wrote the majority opinion in this Young versus Hawaii case, is a brilliant jurist. He took this opportunity to blast the dissenting judge on this case with fact and history and logic. He took this opportunity to blast the entire Ninth Circuit Court of Appeals very nicely, because he acknowledged all of the proprieties of previous rulings and the logic that they've used and all of these things. And in that process, he very gently and kindly and forcefully told them that they're absolutely wrong. And he used Justice Scalia's language to just eviscerate the Ninth Circuit Court of Appeals and the dissenting judge in this case. It was a beautiful thing. Everybody should look up Young versus Hawaii and read it. The history in it will be wonderful to know.
I got to tell you, it's long, right? So you get yourself a cup of coffee. I read it the other day, and I agree with you. I'll tell you, if you want to learn a lot about the history of the Second Amendment and why it is an individual right and why we do fight for what we fight, rather than just feeling like that's right or in somebody's opinion, it's not an opinion, it's a fact. And as you start studying through some of the things that this judge wrote, it is I agree with you, it's a phenomenally well-written decision. Now, obviously, I'm a layperson, I'm not an attorney, so I can't speak to the legalese part of it, but even just from looking at something from a logical argument perspective, this guy laid it out so clearly that it's nigh on impossible, without doing some serious illogical and legal gymnastics and twisting yourself into a knot, to somehow disagree with what he said. And this is, I think, the same. I'm just trying to remember the names. I think this is the same judge who sat on the 3-judge panel for the Paredes case and wrote a similarly well-written decision at the time, isn't it?
It is. It is Justice O'Scanlan. Diarmuid O'Scallion, great Irish name, I think.
I wouldn't
Unless
know.
he's
I'm half
Scottish.
Italian, brother. I have no idea.
But he is the same judge who wrote that ruling in Peruta, which so infuriated the anti-gunners on the 9th that it was a judge who asked for the 11-judge panel to rehear the case. They were so infuriated, and the good justice took this opportunity to spank them legally, logically, morally, and he used the Supreme Court to validate his argument so well. This is why Heller is so important and McDonald is so important. And the words of Justice Scalia, he was able to, in essence, set it up for all gun control issues to ultimately be challenged and overturned based on his argumentation. It was artful. It was, and the beauty is, you're right. I'm not a lawyer. I have a degree in political science, and I did not want to go to law school. Now I've read more cases and more bills and legislation than most lawyers will ever do in their careers. But the argumentation is so good that a layman can get it, and that's a beautiful thing.
It was amazingly well written. It really was. And it's interesting that you mentioned the fact that he used Scalia's argument a lot. It seemed to me that this judge is no dummy. It seemed to me that he was positioning this to specifically for the Supreme Court to reinstate his thinking once the 11-judge panel knocks it back down again. Because I strongly suspect that even if the state of Hawaii doesn't ask for an en banc panel, that same justice or one similar justice that did so for Peruta is liable to step up and ask for an en banc panel, in which case there will be one, and the nutty 9th will probably overturn this decision. But this justice wrote this so well that it seemed to me he was doing nothing but positioning it so that when it gets to the Supreme Court, it'll be nigh on impossible not to simply uphold what he's decided. Ding,
ding, ding, ding. You get a cookie. That is absolutely, yes, you do. That was beautiful, and that is exactly what I think he's doing. And let's talk a little bit about the situation. You have a lot of other circuit courts, a lot of other states that do not necessarily want this case to go en banc, because after reading the ruling by this justice, the case, they're concerned that it'll go to the Supreme Court and the Supreme Court will rule on it, and this will be the law across the land. And some of them I can imagine, are thinking, let the nutty left have open carry in the 9th Circuit. It'll apply only there, but don't send that silliness over this way. So there's going to be some pressure on Hawaii not to ask for an 11-judge panel to be seated to review this case once again. And my guess is that there will be a judge who just cannot hold back, cannot reserve himself to not challenge this case, and it'll probably be the Chief Justice of the 9th Circuit Court, who is an avowed anti-gunner.
Well, that court is full of them, that's for sure.
That's for sure.
So you made a great point. I just want to clarify this, because if it were to go to the Supreme Court, as it stands, if it just stands the way it is and nobody challenges it, and it is what it is, becomes a law of the land, then if I've got this right, that law really only affects the states that are within the 9th Circuit. It does not affect the rest of the country. So in other words, if you happen to be in Wisconsin, then this decision, if it's not appealed and it just becomes the law of the land as it sits, is not going to help the folks in Wisconsin to have open carry if they don't have it now.
That's
because
correct.
It doesn't apply to them. But on the other hand, if it goes to the Supreme Court, the Supreme Court reaffirms it, then that's the law of the land for the whole country, right?
That's correct. That's correct. So the precedent set by the 9th Circuit will apply to the lower courts within that district, within the 9th, the Western United States. And could be cited by other courts, but it is not binding on any other court. It's only binding on the courts within the Ninth Circuit. So, there are some people out there who are shaking in their boots thinking, oh, crap, if this goes to the Supreme Court and it goes the wrong way, and especially if Justice Kavanaugh is confirmed, which I predict will happen most assuredly, this could be the law of the land. And Joel, the important thing, and I think what Justice O'Scanlan did is, you're right. He set it up. He's throwing a softball to the Supreme Court to take this issue on and come up with a ruling that'll be the foundation for us to be able to overturn many of the gun laws throughout the country that are unconstitutional. And here in California, that constitutes the vast majority of the gun control laws in the penal code. So that's a beautiful thing, man.
Well, he took such pains to knock down the arguments of the single dissenting judge, and to do so with research and historical precedent and that kind of things. It just seems to me like, I mean, he pretty much has written the decision for the Supreme Court if it ever gets there. He really has. And I'd like you, I would say just about everybody that's concerned about this ought to take the time to sit down and read it. It's an amazingly well-written decision. You learn a lot of history about it, too.
You sure do.
Well, now, there are some other cases. We had a bunch of wins in a row, and what little hair I've got left, it was blowing back. Another one was also from the Nutty Ninth, which was Duncan versus Becerra, and that's the one I think that upheld the suspension, temporary suspending of the enforcement of the ban on standard capacity magazines that was found in Proposition 63, and I've got people now telling me, well, so this is I need some clarification from you on this as well, because people get a little confused about this. I think I've had a student the other day asking me, well, can I go ahead and buy regular magazines now? Can I buy them? You know, I'm going to go out to my buddy's house in Arizona. Can I buy them and bring them back with me? And I don't think that's true. So help us a little bit with that. What's going on with that? And what can we do and what can't we do?
Okay, the California Rifle and Pistol Association, NRA, filed a lawsuit in San Diego Federal District Court in order to challenge the constitutionality of the magazine ban on Prop 63 and Gunmageddon. There were parallel laws that were passed in the legislature and by the voters through a proposition. The judge down there ruled that the magazine ban is completely unconstitutional. This judge is another wonderful student of history, did an amazing job of pointing out why a ban on the capacity of a magazine is unconstitutional, and he issued a stay against the enforcement of Prop 63 and Gunmageddon with regards to banning those magazines, the possession of those magazines, and requiring people to either destroy them, sell them, move them outside of the state, or convert them into a lower capacity magazine. And so he issued a stay. Now, the Attorney General got mad at that and said he knows better than the federal judge, so he challenged that stay to the Ninth Circuit Court of Appeals, and the Ninth reviewed the challenge. The three-judge panel reviewed the challenge and decided that the San Diego judge did nothing improper. He did everything according to the rules, and the stay stands. So until the situation now is that everybody who legally possesses a standard capacity magazine that holds more than 10 rounds can continue to legally use them. How you use them is a different story, and you have to be very careful. You can't put one of those magazines into a modern sporting rifle because you legally own the magazine and you've got a modern sporting rifle that is California compliant. The minute that you put a high cap mag in, not high cap, but standard capacity over 10 rounds, you manufactured an assault weapon under the law. So please be careful. Now, if you have a registered assault weapon that you registered back in the 80s and 90s, and it had a standard magazine with more than 10 rounds, you could use that. If you had handguns that you owned back then, and you had illegally possess 17-round magazine for your Glock 17, you can use it, but you can't put it into a new Glock 17 or you would be violating the law. So now here's what happens. Now the San Diego judge has to actually try the case. He issued the stay, which did not allow the law to go into effect. Now he has to hold a trial in order to declare the constitutionality of both Prop 63 and Gunmageddon with regards to the magazine ban. If he holds that trial, he's already kind of tipped his hat by using the language that he did to support the Second Amendment to declare the law unconstitutional, hence issuing the stay. So now the trial takes place. Once the trial takes place, then the Attorney General has the opportunity to appeal the trial to the Ninth Circuit Court of Appeals. It's the law. Like I said, I didn't want to go to law school, but I've learned more about the legal process and there are a lot of lawyers out there who are saying, Sam, you're a knucklehead. You got this all wrong because you didn't cross this T or dot this I or use this. Wow. But, that's okay. In general, that is correct.
You brought up some things which I think are potentially, first of all, they're very confusing to the average person. I know because I am the average person, and they're very confusing to me. And I think there are also some landmines in there. So now that we have, let's use me for example. Although I've pretty much removed mine, but nevertheless, I did when I bought my Mini 14, for example, many moons ago, back in I think 1990 or 89 or something. I bought a bunch of magazines for it, and of course back then they were 20s and 30s and like that.
Right.
And so now that and they've been legal all this time because the mags that I bought prior to the ban were grandfathered in. I couldn't buy new ones. I couldn't go to another state and bring them here or whatever, but the ones I had were grandfathered in.
Right.
Now we have, essentially because of the Gunmageddon, we basically have three different kinds of semi-automatic rifles in this state. We have the kind that are now registered as assault weapons. And here's the confusing part. People say this to me all the time. Well, yeah, but it was registered when I bought it. No, that's true, probably, but no, it's a separate registration where you actually registered that rifle as an assault weapon. So now it's registered as an assault weapon. Then you have the California compliant rifle. That's the one that's not registered as an assault weapon, but has a fixed magazine in it. So that even though it may have a flash hider or pistol grip or collapsible stock, the magazine cannot be removed from the gun without taking the gun apart. And so as a result, it's California compliant. It complies with the law. Mm-hmm. And then you have the featureless rifle. That's the one that you took your AR and you no longer have a flash hider, you don't have a muzzle device at all maybe, or you have a muzzle brake or something, but it's not a flash hider. You don't have a collapsible stock anymore, you got a straight stock, and you don't have a pistol grip because you bought one of those crazy grips, or you bought a stock that works or whatever to be within the law. Now that rifle, just like a Mini 14 or some other rifle that's compliant because it doesn't have those features, that's a featureless rifle. Now I've got my magazine, okay? My understanding is, let me make sure I got this right, I cannot put my magazine, my normal capacity magazine, that even though the magazine is now legal for me to still have because they can't enforce the law because the judge says you can't enforce it until it gets through the court, I cannot put my legal capacity magazine in my registered assault weapon because it's more than 10 rounds. Is that correct?
If you have a legally registered assault weapon that you registered back with the Roberti Roos and the Parada assault weapons ban, the one back in the
name and model one, right? Where it was the Colt, whatever,
or the description, the first description gun,
right? Back in
back in the early 90s. If you had that one, you can use those magazines and you can use that gun. Okay?
But if I just registered it recently in July, can I use it in that gun?
No, I don't No.
Boom, that mine just went off. Okay.
You're manufacturing an assault weapon.
Okay.
To the law.
Okay, so if you have a gun that you registered as an assault weapon because of the changes in the new law, and you did it before July 1st, you cannot use that magazine that holds more than 10 rounds in that gun.
That's correct.
Okay, we got that. So now if you have one of those, don't put the standard capacity mag in it because you've just committed a felony. All right, now I have a California compliant rifle. That's different. That's the one where I used some device like the Elemental Arms one or the AR mag lock, or I bought a comp mag and I put it in there. But one way or the other, it's considered a fixed magazine rifle. And as a result, it's California compliant because it's not a semi-automatic rifle that has a detachable magazine. If I then take my 10-round fixed magazine out of that rifle and I put my 30-round or more than 10-round fixed magazine in that rifle, it seems to me I cannot do that either. Is that correct?
That's correct. And Joel, just to make sure that our attorneys don't jump out of their seats and jump off the roof and stuff like that.
Yeah.
What we are talking about are our opinions. You cannot constitute this as legal advice.
No, please don't.
We're telling you what our observations are with regards to the law. And that comes with me being involved for well over 30 years in this process, watching virtually every anti-gun law that's ever been put on the books. I was here when it passed, fighting it all the way. Sometimes we succeeded, and oftentimes we did not, given the situation. But that being said, this is not legal advice, but you are correct. It's legal to possess the magazines, but putting them into guns, you're
at risk of getting arrested. You really
Yeah.
are. Okay, so we've done, and I'm going to double down here on the disclaimer.
Go for it.
I have a college degree in opinions. That's all I got. Okay, I never finished college. I'm not an attorney, so please don't take any of this as legal advice. This is a warning to go check with your attorney and make sure that you got this right, or the book that you can buy that maybe you can sort it out for yourself. But these are some things I know I'm not going to do. First of all, I haven't got any, but if I had a magazine with more than 10 rounds, I wouldn't put it in a registered assault weapon because I don't have one, and I wouldn't put it in a compliant rifle. I do have one of those. Now, let's talk about the featureless rifle. My Mini 14, because it has a standard rifle stock on it and it has no pistol grip, it does not have a muzzle device of any sort, it does not have a collapsible stock, it's just a standard rifle stock. And so there's no collapsible stock, no pistol grip, and no muzzle device. Is a featureless rifle. Never mind the fact that it has precisely the same capability as an AR-15 or anything else. But nevertheless, I can have a detachable magazine in it because it doesn't have any of the features. I can take my mag out, I can put my mag in, doesn't matter. If you have an M1A or something that's structured the same way, you can do that. Or I have a Sega, however you want to say it, hunting rifle that is a 7.62 by 39, same thing. Those are featureless rifles, and you may have taken your AR-15 and made it featureless, which means you didn't have to register it. It's not California compliant because it's not a fixed mag rifle, but because it doesn't have the features that everybody thinks make rifles horribly dangerous, you can have your detachable magazine. It doesn't matter. And here's the question, Sam. I know you are. I'm not, but you are. Can I take my now, at least temporarily, still legal magazine that holds more than 10 rounds and put it in my featureless rifle?
The answer to that question is, if you do that, there is a high likelihood that you will be arrested, your firearm will be confiscated, and you will have to go to court hiring California's best gun attorneys to try to prove yourself innocent and try to prove the laws unconstitutional. Joel, it boils down to this. If you have high-capacity magazines, standard capacity magazines.
I know they got me saying it too. Trust me, I know. I get it.
I think I mentioned before when I was younger, before all of this foolishness happened, I used to go to gun shows and I was penniless. I mean, I had $5 in my pocket, but I would use that $5 to go to virtually every gun show. A dealer had a cardboard box with Vietnam era M16 magazines in there. Yeah. And they were cool because guys would write their unit numbers on them and spray paint them, and they were cool. And they'd sell them $2 for $5. Yeah. And they were 20-round magazines. I found some 30s, and so we had a whole bunch of them. So those are legal for me to possess. I can own them. If I had a legally registered 1989 to 1992, whatever the original assault weapon registration was, I could use them in those guns, but I can't use them in anything else.
So the bottom line here is, This thing is still being adjudicated. It's still going through the court system.
Yes.
All that has happened is that although the law is on the books saying that they are illegal to possess, which, by the way, means that currently they are illegal to possess. All that's happened is that the court has said this is going through the court, and so even though they are illegal to possess, it is that the state, the government, cannot enforce that law.
That's correct.
That's all that's happened. So
Yes.
they're still illegal to possess within the state. The difference is law enforcement and the courts cannot enforce that law until until a judge says so, or until it has finished going through the court system and the court actually makes a decision as to whether that law is constitutional or not. So, and I think that's what you're telling me. First of all, am I right about that?
Yes, you are.
Okay, and then secondly, the advice that you're going to get from me as a non-attorney, not even close, I'm not even a college graduate, as a man who's got a graduate degree in opinions, that's about it, which just means I have opinions and I'm happy to share them whenever I can, is if you have those magazines, if it were me, I would not use them currently. I would just hold off, so that you don't accidentally find yourself on the wrong end of the law. I would hold off and wait and see what happens as this thing works its way through the court. But at the moment, because they can't enforce it, you don't need to take them out of the state or bury them in your backyard or whatever the case might be.
That's correct, Joel. And here's the easy way to do it. If you have a piece of paper signed by the Attorney General that says you have a legally registered California assault weapon back when our Attorney General was someone other than our present Attorney General, you're good to go. If you don't have that piece of paper that gives you that authorization, you are not good to go.
And that's from the Roberti Roos ban, the
Correct.
first ban, not the most current one.
And
right.
if you don't have I know a lot of gun owners spend all of their available resources to buy ammunition, to buy bullets and powder and primers and reload, and they
Sure.
go to the range and enjoy it. And they don't have the resources to pay $500 an hour, $350 an hour to talk to an attorney.
Oh, yeah.
California gun laws, a guide to state and federal firearms regulations. It's available. You can call us here at Gun Owners of California. We can get you a copy. It was written by Chuck Michelle and his team of attorneys. It covers all of the laws in the state of California that affect you, whether they're federal, state, or local laws, and will answer all of your questions. It's well written, and it keeps growing every year. It started out about that wide, and it is now this wide. Every year it gets bigger and bigger. This is the next best thing to an attorney. Don't listen to us. Get it from the horse's mouth, and here it is, although we're saying what's in here. So
well, and that's the number that you're seeing on your screen right now is the phone number for Gun Owners of California, so that way you don't have to look it up. While you're on the phone with them, you might want to join.
that would be greatly appreciated.
I am a member of Gun Owners of California. My wife and I figured out the other day that she's not, so she will be probably sometime this week or over the weekend or next week or something, because you should join if you haven't already joined Gun Owners of California. Please do that. One of the things I've realized over the years is that, I'm a life member of NRA, I'm a life member of California Rifle and Pistol Association, and Sam, if you ever offer a life membership, let me know. My wife and I will join.
You will be number 2.
Okay, good.
I have a guy who's been waiting for a while to be number 1.
My wife will be number 3.
Thank you.
Okay, but these organizations, and one of the things I've discovered in talking to Sam and talking to Rick over at CRPA and talking to the folks at Gun Owners of America, join them too, is that these organizations really are joined at the hip in the sense that they work together and specialize in different things. They've figured out over the years who's good at what and who's good at the other thing, and they work together on these cases. So it's important that we support them all to the degree that we can. I realize it costs money and so on, but then I keep asking myself, how much are your rights worth? We can sit back and complain, or we can actually sign up and help. So anyway, that's my pitch for membership for Gun Owners of California today.
Thank you, Joel. Greatly appreciate it.
You're quite welcome. There was another one that I think is fascinating, and that is the defense distributed settlement, which has been long coming. And let me read you, Sam, before I get started, and I'll explain what that is. Defense Distributed is the company that had originally developed a neat little program for a 3D printer so that you could print a gun. And they started distributing that, and then the federal government got all over them and said you can't do that, so they stopped and complied, and they sued, along with, was it Second Amendment Foundation? I don't know. Somebody sued with them. And the result is that they got a settlement out of it, and there were two things in the settlement I thought were interesting. One was the fact that that as a First Amendment thing, they said, no, you can distribute this if you want to. It's a First Amendment issue. You can distribute it on the internet. And then the other issue was that I found it interesting that the government somehow in that paperwork, I was reading it in that settlement, alluded to, in fact, I think pretty much said that semi-automatic civilian type firearms and the like of AR-15s are not necessarily weapons of war. We hear that out of the left all the time. Now, there is a story, Sam, today in the news. Let me read that to you real quick. This is in the Hill, and it says anti-gun violence groups file to halt online posting of 3D printed gun plans. Three prominent anti-gun violence groups filed a motion early Wednesday to block a settlement that would allow for plans for 3D printed firearms to be posted online. The Brady Center to Prevent Gun Violence, Everytown for Gun Safety, and Giffords Law Center, sorry, I had to get that out of my mouth there, jointly filed in U.S. District Court in Texas an emergency motion to intervene and an emergency motion for a temporary restraining order and preliminary injunction in the case. And then it goes on to quote the Brady folks. But anyway, it seems like that's now in the courts still. Any thoughts on this thing?
Oh boy, this is huge. Professor John Lott, the author of More Guns, Less Crime, he came out with an article last week that said that this is the issue that has destroyed gun control. The fact that anybody has the constitutional right, according to the First Amendment and the Second Amendment, to upload this information and to manufacture their own firearm. The firearms they manufacture are legal, and the only time they break a law is if they manufacture an illegal gun. The courts or the ATF originally tried to stop this from happening because they said that this was a violation of international law, marketing of firearms, because some international people were downloading the code in order to make their guns, and they said that it's the same thing as if we were shipping guns internationally without a license. So that argument was thrown out of the water, and the government realized, yeah, we're violating First Amendment rights, freedom of free speech, and the Second Amendment. It is legal for people to manufacture their own guns. So they came up with a settlement that that's what's going to happen. And the anti-gun people, they're so misnamed, gun violence and all this stuff. That it's anyway. Well,
I agree with you, but you're right.
Yeah,
anyway,
yeah, they're gonna lose, and people are going to have the ability to buy a 3D printer, whether they buy one that works in plastic or one of the newly released 3D printers that work with metal. They're becoming more and more affordable. People will have the legal ability to manufacture their own guns at home as long as they don't sell them or use them illegally. There's nothing wrong with that.
Well, what's interesting about that statement is I've been watching the news a lot, and you get this hyperbolic nonsense that somehow because of the release of now the First Amendment right to actually share information, what a concept, and the Second Amendment right to make your own firearms. Well, you know what? It's already legal to make firearms. Even in the state of California, you can get, what we quaintly call the 80% lower, and you can make the firearm. The only thing is the state of California requires you to register it and get a serial number on it. But it doesn't. There's no prohibition in the state of California against building your own gun. You just have to if you want to have it legal, you got to put a serial number on it. And you got to register it. That's it. Correct. And in most states, you don't have to do that. You build it and make it, and as you said, as long as it's not an illegal firearm, it's not an NFA thing or something along those lines. The ability to make your own firearm legally in the United States already exists. Mm-hmm. So nothing has changed here except the sharing of information on the internet and the mode by which, or the tools by which the firearm is actually made. So this whole idea of the ghost gun nonsense is exactly that. It's just nonsense. You can go out and buy. So what's the difference between? Here's the difference. You can buy a 3D printer that prints in plastic or polymer or metal. In fact, if you want to get one, you can get one from Defense Distributed. They got one, I think, that prints in metal that they're offering. Or you can buy an 80%er and you can get yourself a drill press and the appropriate mill tools and like that. The only difference is the tools that are used. That's it. So I'm just going to share with you, in my humble opinion, that this is all nonsense. And it's a great ruling for the First Amendment and the Second Amendment. It really, really is.
Joel, the left is apoplectic right now, trying to figure out how can we require registration and background checks for the sale of 3D printers, and how can we prevent people from getting these dastardly devices that will allow people to, now criminals will be able to buy a 3D printer and manufacture their own guns. Well, here's a secret for you, Einstein. Criminals have been stealing or manufacturing guns since forever. Senator H.R. Richardson, our founder and chairman, when he served in the legislature, every year he went around to the state's prisons and talked to the prison guards and asked them about the weapons that were manufactured within the walls of the prisons. Single-shot silenced firearms were regularly manufactured. These guys are brilliant. Criminals are not stopped by any of these laws. These laws only affect law-abiding citizens who have no intent on doing anything illegal. And their rights should supersede whatever intention you have for the criminals. We should be focusing on crime control, going after the bad guys for breaking the law, and not creating laws that make good guys criminals. That's what gun owners is all about.
Well, I mean, criminals are called criminals for a reason, because they're criminals. Yeah. They don't obey laws anyway. What a concept! And and law-abiding people are called law-abiding people because they are by nature law-abiding. This shouldn't be rocket science. It's not. This is not brain surgery. It's pretty simple to figure this out. Now, look, these are not. This exciting part about this for me is, I hate to lose, Sam. You know that. I love to win. And we do a lot of, unfortunately, we fight these battles and we get slapped down a lot. And even these wins that are not yet fully baked, I mean, they're baked to the point that they are, and they still need to be in the oven a bit. We got to work on them some more. These are three huge, incredibly encouraging victories, one right after another. I'm just blown away by it. I mean, and they're not the last ones. There are other things bubbling up, are there not?
Yes. I don't know if you can see the hair standing on my arms. I'm so excited about what you just said, because you are absolutely correct. We have cracked the doors open to victory, and we see victory. We just have to keep plowing ahead and doing what it is that we're doing. We have to continue to fight in the legislature, even though that's where we're going to lose the most. We have to continue to fight in elections in order to cut our losses within the legislature. And we have to continue the most important thing that we're doing right now, and that's fighting in the courts, supporting the organizations that file the lawsuits, supporting the organizations that are writing the amicus briefs who add body and breadth to the lawsuits that are filed by these organizations, that are absolutely read by justices when they make their decisions and their rulings. This is so exciting. Victory truly is in our sight. There is a huge potential that the next case that makes it to the Supreme Court could open the door for us to challenge every single one of the anti-gun laws that are on the books in the state of California. Every one of them. And that is what we are pushing for. And to some extent, it doesn't matter which case makes it to the Supreme Court. The issues that the Supreme Court's going to have to decide, regardless of the primary issue, are going to be beneficial to California and to the rest of the country.
Well, with Kavanaugh being on the court, and then my hope is, and I'm just going to say this. Look, I see people ragging on President Trump because of this, that, or the other thing. I'm in my 60s. There's never been a president I agreed with on everything. There never will be. But I got to tell you, what this man has done so far for the Second Amendment in appointing conservative, constructionist, originalist judges, not just to the courts of appeals, although the Ninth Circuit is difficult because, as you've explained before and as we've talked before, he has to take if he's going to, if one of the justices has to come from Hawaii, which is the one that he most recently appointed, he had to select a justice from Hawaii. He had no other choice, and the pool was really rotten, so he picked the best one out of the bunch. But nevertheless, the Fifth Circuit has almost turned entirely constructionist and conservative by virtue of President Trump's appointments, which means that, one, we need to support the man, and two, we absolutely have to vote Trump-supporting people into the Senate and the House. We can't stay home. We cannot stay home. We can't forget to get to the polls. We've got to get to the polls, and we've got to make sure that Trump-supporting people are running the Senate and running the House so that he can continue to get those justices approved, so that he can continue. The only reason we don't have right to carry reciprocity right now is there aren't enough votes. That's the reason it hasn't come to a vote. It's not because, I mean, that gets right down to it. That's the reason we don't have it, is there aren't enough votes between the House and the Senate to make it pass. We got to get more people in there that will support Trump and support that. And if we go to the polls nationwide, and even here in California, you know, that we got rotten senators, but there are some Congress members in California that are very conservative. Mine, for example. Mm-hmm. You know, we gotta vote these folks back into office, and we got to replace them if we can. If we do that, we have a really good shot of totally changing the judiciary in the favor of the Second Amendment, in the favor of the Constitution. And I think that's why we're starting to see this come around. And as I said, there's more cases. I was reading about it today. There's the Flanagan versus Becerra case, mm-hmm.
which
actually I would love to have you expand on, because doesn't that have something to do with Peruta?
Yes. What it does is it goes back and deals with the issues that the court used to, destroy Peruta. Basically, it's making its way through the process. We believe that this is the case that's going to ultimately make it to the Supreme Court. It has to do with carry, concealed carry, and open carry. It resolves or addresses the issues that the court used to criticize Peruta. So it's a cleaner case. It'll make it up, and there is a very good chance that the Flanagan case is the case that's going to make it to the Supreme Court. Front and center, man. You're absolutely right. What the president does and what the Supreme Court does now is going to affect us for the next 100 years. With the precedents that they set, the defense of the Second Amendment, all of the other issues that you might disagree with the president on in the future, we have a chance of addressing if we guarantee that the Second Amendment is restored and protected. We do that, then we have learned how to fight and what we have to do on anything else that is of concern to us with regards to our constitutional rights. Very, very important. Our folks are the people that cannot stay home. Those people who support the Second Amendment above anything else, no matter what else is out there that affects you. If you support the Second Amendment, you are going to be, you need to get out and vote. It's an essential thing, and you need to get everybody in your family to vote, everybody at your gun range, everybody at work, and you need to explain to them, hey, this is so important. Your Second Amendment right, your ability to protect yourself in your home, in your travels, and in your business rely on you going out and voting this year. So don't give up that responsibility.
I'll tell you the other thing I want to point out too, and I know I'm sounding like a shill or a commercial or something, and if I am, well, get over it. Okay, because maybe I am a shill or a commercial. The Constitution is incredibly important to me, and it's incredibly important to citizens of this country. It's the founding document that makes this country great. I'm looking at 1, 2, 3 victories we had right out of the gate. Bam, 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 just like that. Now, these things have been in the court for a while. It's not like they happen immediately. But nevertheless, these things happened because lawsuits were filed, and lawsuits cost a lot of money. Mm-hmm. And that's why not only do we need to vote, But I got to be honest with you, I'm just a working stiff, but I'm trying to set the example here by joining organizations, supporting organizations, giving money to organizations that do this, because I can't do it. I can't come up with $150,000 or $200,000 to file a lawsuit. I can't come up with $15,000 or $20,000 to write an amicus brief. I don't have the money to do that. But collectively we do. Not only can we not sit home on our fannies and not vote, but we can't sit home on our wallets and not contribute. And even if it's $5 or $3 or $2 or $20 or $1,000 or whatever we can do, we've got to support NRA, CRPA, Gun Owners of California, Gun Owners of America, Second Amendment Foundation. We've got to support these groups. And there are others. Those aren't the only ones. I'm a life member of NRA, CRPA. I'm a member of Gun Owners of California, life member. I'm going to say over there, too.
I hear you.
Too, if you ever do it. I'm a life member of the Second Amendment Foundation. Between now and the end of the year, I'll be a life member of Gun Owners of America. My wife is also planning on joining all of these organizations between now and the end of the year at the same level. We're trying to set the precedent for you, set the example for you. I got to tell you, you got to help. You can't just sit on your fanny. If you do, just sit on your fanny or sit on your wallet, and things go sideways, you'll always have a right to complain about it. But you're going to have to look in the mirror and say, I'm complaining about it, but then you got to ask yourself the tough question: what did you do to make a change? I'm always going to honor your right to complain. So you can call me and complain, you can send me notes and complain. But if you didn't do anything to change it, that's going to be tough on you when you stare in the mirror and realize your rights are gone. We're starting to win. We got to keep winning. Anyway, there's my speech today. I'm sorry.
Joel, that was well done. Winston Churchill himself couldn't have done a better job.
Particularly since he's dead.
Yeah.
Is there anything else you wanted to talk about, Sam? I've kept you here for an hour. I apologize.
No, this is beautiful. This is so important. Your listeners need to understand. You are absolutely correct. We are winning. We are winning. It has taken us years of preparation to get to the point here where we are winning. And it's going to take years for us to ultimately claim that victory. But now is not the time to stop. We don't have Bloombergs and Soroses and people out there to give us $1 million here and $2 million there, $15 million there. We do it all by the support of people who give between $5 and $35 a year to help us fight this fight. That's how we win. That's how we know that we have the support of America, because we have thousands and thousands of people who are willing to do that. We got to keep that going. We cannot fail at this point, because we are on the verge of massive victories. And I appreciate you for being a voice out there for freedom and liberty, for giving me a chance to come and share this stuff with you. And if I get in trouble legally with my lawyer friends, I'm sorry. But this is what people need to know. And if anybody has any questions, you need to be armed and informed with the truth. Listen to GunGuyTV. Call us at Gun Owners of California, 916-984-1400. Don't run around out there with a question in your mind. Be armed and informed with the truth so that you can share it with other people and get them enthusiastic about fighting for their rights.
Well, once again, I want to tell you that number you're seeing on the screen is the number for Gun Owners of California. You just heard Sam tell you what it is, but that way you don't have to look it up. Also, there is a link in the description so you can go directly to their website, directly to their Facebook page. Sam posts some great information on the Facebook page on a regular basis. I try to do the same on mine. I think he might be a little bit more efficient about it than I am. So you want to check these various things. But I'll tell you, there's a couple things I would do, and one is call them, join, contribute, and buy that book. If you're in the state of California, buy that book. That thing is worth its weight in gold, and it'll keep you out of prison. It's not a tremendous expense, but it was written by some of the finest lawyers in California where the Second Amendment is concerned, and they keep it updated on a regular basis. And they write it, pretty much for lay people like me and Sam, He's less of a
Yes.
layperson than I probably, but I mean, they write it so that we can actually get it and figure it out. It's not necessarily written in legalese, so you can actually get a book that will help you a lot. Sam, thank you very much for being on the show. I really appreciate your time. You're one of my favorite people. I love having you on. We will do it again. We will do it again very soon.
Man, I feel like we're brothers from another mother. I appreciate you giving me the opportunity to offer my opinions and my concerns and my encouragements. So God bless you, and thank you very much, Joel. Look forward to doing it again.
Absolutely. Thank you very much for watching. Again, if you don't mind doing something to support GunGuyTV, we always appreciate that. But truthfully, if it's a difference between doing that and joining Gun Owners of California, please, I'd actually prefer that you do that. That money is very, very well spent there. Look for us on all of these other platforms you're seeing on your screen. We're no longer prisoners of YouTube, so you'll be able to find us. And if something goes wrong here, you'll be able to find us any of those other places. So I urge you to pick one or two or three and go subscribe or whatever they call it, friend us or something on one of those so that you won't lose track of us. And of course, we'll have Sam on again when we have more to talk about. In the meantime, please be informed so that you don't make a mistake and get yourself arrested. And whatever you do, wherever you go, please be safe.